In a significant development, the Supreme Court today granted interim bail to social activist Teesta Setalvad, who is under custody since June 26th over the alleged fabrication of documents to file cases in relation to the 2002 Gujarat riots. She has been asked to surrender her passport by the Supreme Court today until the matter is considered by the Gujarat High Court. The order today was passed by a bench comprising the Chief Justice of India, Lalit, and Justices S. Ravindra, Bhat and Sudhanshu Dhulia after Setalvad moved the Supreme Court against a Gujarat High Court order which had given a long adjournment in Setalvad's bail plea while not passing any order of interim bail. Pertinently, the Supreme Court today noted that Teesta, a lady, has been in custody since 2 months and that the investigative machinery has had the advantage of custodial interrogation for a period of 7 days. The bench also noted that the offences alleged against Teesta pertain to the year 2002 and at best the concerned documents were sought to be presented till 2012. Thus, the court ruled that the essential ingredients of the investigation, including custodial interrogation, having been completed, Teesta is entitled to the grant of interim bail. Senior advocate Kapil Sibal, appearing for Teesta today, argued that the facts narrated in the FIR against her are nothing but repetition of proceedings which had ended with the Supreme Court's judgment dated June 24 this year, and that the offences alleged against Teesta are not even made out. Solicitor General Tushar Mehta, appearing for the Gujarat government, on the other hand, argued that the application of bail is pending consideration before the Gujarat High Court, and as such the matter must be allowed to be considered by the High Court rather than entertaining it at this stage. He also added that there is sufficient material apart from whatever has been adverted in the FIR pointing Teesta's involvement in the alleged offences. Additional Solicitor General of India, S.V. Raju, also appearing for the government, submitted today that even if the forgery complaint has to be filed under Section 340 of the CRPC, the bar under Section 195 would apply to the stage of cognizance and not at the stage of FIR, which is where the case is at the present stage. Yesterday, the bench had expressed its inclination to grant interim bail to Teesta, but had ultimately adjourned the hearing for today pursuant to a request made by the Solicitor General of India, Tushar Mehta. Pertinently, the bench yesterday had also pointed out that 4 or 5 features of the case are bothersome, which are as follows. Number 1, Teesta has been under custody for over 2 months and that no charge sheet in the case has been filed. Number 2, the FIR was registered on the very next day of the Supreme Court dismissing Zakir Jafri's case, and the FIR does not recite much anything other than the Supreme Court's observations. Number 3, the Gujarat High Court, while issuing notice on Teesta's bail plea on August 3rd, granted a long adjournment, making the notice returnable by 6 weeks. Number 4, the offences alleged are not serious like murder or bodily injury but pertain to the alleged forging of documents filed in court. And number 5, there are no offences which bar the grant of bail. During the hearing yesterday, the bench had also made some strong remarks against the Gujarat High Court's order of adjournment after noting that the High Court had issued notice on Setalvad's plea on August 2nd but had posted the matter for further hearing after 6 weeks, that is on September 19th. These particular remarks had been made by the bench about the long adjournment given by the Gujarat High Court in response to the Solicitor General's argument that this was not an exceptional case where the Supreme Court should intervene. For a detailed coverage on yesterday's hearing, you can refer to our earlier video, the link to which has been given in the description box below. To provide a brief context for our viewers who are not aware about the case, Teesta was arrested on June 26 from Mumbai by the Gujarat Anti-Terrorism Squad a day after the Supreme Court dismissed the petition filed by Zakir Jafri challenging the Special Investigations Team's clean chit to high-ranking state functionaries and the then Gujarat Chief Minister Narendra Modi in the alleged conspiracy behind the Gujarat 2002 riots. While dismissing Zakir Jafri's petition, a bench led by Justice A.M. Khanwilkar had blamed the petitioners for keeping the pot boiling and showing the audacity to question the integrity of the special investigation team, and had observed that all those involved in such abuse of process need to be in the dock and proceeded with in accordance with law. The very next day, the Gujarat Anti-Terrorism Squad arrested Teesta Setalvad, R.B. Sri Kumar and Sanjeev Bhat, who is already serving imprisonment in another case, in the case for allegedly fabricating documents to frame high-ranking officials in the state, including the then Gujarat Chief Minister Ravindra Modi, in the 2002 Gujarat riot cases. This is Aratrika Bhaumek for LiveLaw. If you want a detailed coverage of today's hearing, you can refer to our report, the link to which has been given in the description box below. Thank you. Keep watching LiveLaw for more such updates.